Can you believe an HOA would try to fine you thousands of dollars for a garage that stood perfectly fine for over 20 years? When I bought this home back in '98, I never imagined that the very structure protecting my cars and family memories would become the center of a battle with power-hungry neighbors. But what they didn't count on was the decades of paperwork I had saved, and the judge who would ultimately expose their corruption for all to see. Comment below with the craziest HOA rule you've ever encountered, and hit subscribe so you don't miss the shocking courtroom twist that left these board members speechless. It all started on a Tuesday morning. I was enjoying my coffee on the porch, watching the neighborhood come alive like I have every morning for the past 25 years. The mail carrier arrived, and among the usual bills and advertisements was an official-looking envelope with the HOA letterhead. Nothing unusual there. Our HOA sends out quarterly newsletters and occasional reminders about community events. But this was different. As I opened it, my eyes widened at what I was reading. It was a violation notice stating that my garage was in non-compliance with newly updated community aesthetic standards and that I was being fined $5,000. I read it again, certain I had misunderstood. The notice claimed my garage's paint color was not on the approved palette and that the style and condition of the garage doors were inconsistent with community standards. This was absurd. My garage was the exact same color and style as when I purchased the house in 1998. I hadn't changed a thing. I immediately called my neighbor Bill, who had lived across the street since the neighborhood was built in the '80s. "Bill, did you get one of these garage violation notices?" I asked, trying to keep my voice steady. "Sure did, Jim," he replied, his voice weary. "Got mine last week. Same story. 5-0 fine for my garage that hasn't changed since 1987. What is going on with the HOA? I wondered aloud. Who's making these decisions? That new board president, Linda Thompson? Bill explained. She moved in about 2 years ago and somehow got herself elected president last year. Since then, she's been targeting the older homes in the neighborhood, claiming they don't meet modern standards. I remembered Linda Thompson, a woman in her late 40s who always seemed to be walking around with a clipboard, taking notes. She had made several comments to me about how charming but dated my property was, but I never thought much of it. The next day, I attended the scheduled HOA meeting, violation notice in hand. The community center was packed with confused and angry homeowners, many holding similar notices. When it was my turn to speak, I approached the microphone. "I'd like to understand why I'm being fined 5-0 for a garage that hasn't changed in the 25 years I've owned this home," I said calmly. "Can someone explain what newly updated community aesthetic standards you're referring to?" Linda Thompson, sitting at the head table with her fellow board members, smiled condescendingly. "The board voted to update our community standards last month, Mr. Henderson. All homeowners were notified of the changes via email and given 30 days to comply." "I never received any email," I replied. "And even if I had, how can you retroactively fine homeowners for structures that existed long before these new standards were created? The standards apply to all properties in the community, regardless of when they were built or modified," she stated firmly. "It's all in the bylaws." The meeting went downhill from there. Homeowner after homeowner stood up to question the fines, only to be met with dismissive responses from Linda and her board. When I asked to see the specific bylaw that allowed for retroactive enforcement of new standards, Linda told me I could request the documents through a formal process that would take weeks and cost me $50 for administrative fees. As I left the meeting, frustrated and angry, Bill caught up with me. "This isn't just about garages, Jim," he said quietly. "Linda and her cronies have been systematically targeting the older residents of this neighborhood. My friend Margaret got fined 3-0 for her garden decorations that she's had for 15 years. George was fined for his mailbox, which is the exact same style as half the mailboxes in this community. What can we do about it?" I asked, feeling defeated. "We need to fight back," Bill said firmly, "but we need to be smart about it. Linda's got the board majority, and they're changing rules faster than we can keep up. If you think this HOA is out of control now, just wait for the twist coming up. Subscribe so you never miss another instant karma story." Over the next few weeks, things escalated. I received another notice, this time stating that if I didn't pay the 5-0 fine and bring my garage into compliance within 30 days, the HOA would place a lien on my property. I couldn't believe it. They were threatening my home, the place I'd raised my family, made memories, and planned to spend my retirement years over a garage that had never been an issue before. I decided to consult a real estate attorney, who confirmed what I suspected. The HOA was overstepping its authority. They can't just change rules and then fine people for not complying with retroactive standards, he explained. But fighting this will take time and money. Meanwhile, I started doing some digging. I went through all my old paperwork from when I purchased the house and found something interesting. The original HOA bylaws included a grandfather clause that specifically protected existing structures from future aesthetic standard changes. It was right there in black and white. Armed with this information, I requested a meeting with the HOA board, bringing my attorney with me. Linda seemed annoyed to see us, but agreed to hear us out. My attorney presented the grandfather clause from the original bylaws. As you can see, Mr. Henderson's garage and all other structures existing at the time these bylaws were written are explicitly protected from future aesthetic standard changes, he explained. Linda smirked. Those are the old bylaws. The board voted to update them last year, including removing that outdated grandfather clause. You can't just remove protections that were in place when these homeowners purchased their properties, my attorney countered. That's a fundamental change in the agreement that would require unanimous consent from all homeowners, not just a board vote. The meeting ended in a stalemate. The board refused to withdraw the fines, and we refused to pay. A week later, I received a certified letter informing me that a lien had been placed on my property for the 5-0 fine plus 1,500 in legal and administrative fees. I was devastated. How could this be happening? I had worked my entire life to pay off my home, and now these power-hungry neighbors were threatening to take it away over a garage that had never been a problem before. That's when Bill came to me with some interesting information. I've been talking to some of the newer homeowners, he said. Linda's been telling them that these fines are necessary to improve property values and that targeting the older homes is for the good of the community. But there's more, he continued, lowering his voice. I have a friend who used to be on the HOA board before Linda took over. He told me that Linda and her allies have been using HOA funds for personal expenses, fancy dinners, trips, even home improvements at their own properties. They're running this HOA like their personal piggy bank. This was the break we needed. With evidence of potential financial misconduct, we had grounds for a formal complaint to the state's HOA Oversight Board. But that process could take months, and the lien on my property was causing real problems. I couldn't refinance or take out a home equity loan if I needed to, and it was damaging my credit. My attorney suggested we take a different approach. Sue the HOA in civil court for harassment, selective enforcement, and financial misconduct. It was a bold move, but at this point, I felt I had no choice. The weeks leading up to the court date were tense. Linda and the HOA board continued their campaign of intimidation, sending out newsletters that implied homeowners who didn't comply with the new standards were dragging down property values and being selfish. They even hired a property management company to drive through the neighborhood taking photos of supposed violations. I was nervous as I walked into the courthouse that morning. Bill and several other affected homeowners came to support me. Linda and her board members were there too, looking confident in their expensive suits. The judge, a stern-looking woman in her 60s, listened patiently as both sides presented their cases. Linda's attorney argued that the HOA had the right to update its standards and enforce them uniformly across the community. He presented photos of various properties, including mine, that he claimed were diminishing the aesthetic appeal of the neighborhood.